Thank you very much. In the interest of time, and because there is so much to talk about with regard to the three previous presentations, I will be briefer. Linda, can you give me a nudge at 10 minutes?
Absolutely.
Okay. To complete our discussion of international law issues this morning, I'd like to introduce you to a new treaty, the Hague Choice of Court Agreements Convention, which the United States signed in January and which is now under consideration for submission to the Senate for advice and consent to ratification. If it is in fact approved and implemented, and which I think is likely, it will have an impact in your courts. So this is something to pay attention to. It's not abstruse or esoteric. It is likely, I think, in the next year or two to show up as an operative document in state as well as federal courts. So it's well worth paying some attention to and considering, and in particular because it raises the question, which if there is a common theme among our panelists today, it's a question of the limits, if there are any, on the ability of non-U.S. parties to bring cases into U.S. courts, both state and federal courts. I've been sitting imagining what questions you might have in mind, and one that if I were in your position I might ask is, why are these cases in my court and what do I do with them? And the Choice of Court Convention will answer both questions, at least with regard to contractual matters. The Choice of Court Agreements Convention was adopted in 2005 by an entity called the Hague Conference on Private International Law. Now, some of you have probably encountered the Hague Conference in the context of one or more of its well-known treaties, both in the area of family law, child abduction and child adoption, but perhaps also in the context of the Service Convention or the Evidence Convention, or maybe even the, my favorite, the Apostille Convention. And this is another in the series of private international law conventions which have been negotiated and adopted in the Hague Conference and to which the United States is anticipating becoming a party. The convention to date has been ratified only by Mexico, but as I said, the United States is a signatory, the EU is a signatory, and a number of other countries are considering signature and ratification actively: Argentina, Australia, Canada. It's likely this treaty will come into force in the next few years. The essential provisions of this treaty are rather simple to describe to you. There are three basic rules and an optional fourth rule. The three basic rules are as follows. First, a court in a contracting state, which has been chosen by the parties as the forum in which the dispute arising under the contract should be resolved, has and must exercise jurisdiction to decide the dispute if it falls within the term of the treaties. Now, this, of course, relates to forum selection clauses, or we might call them choice of court clauses in contractual matters. So there's an obligation on the chosen court to decide the case, to take jurisdiction and to decide the case. Secondly, a court not chosen by the parties does not have jurisdiction and must either suspend or dismiss the proceedings if in fact they are brought in the non-chosen forum. And third, importantly, and here's the connection to Linda Silverman's presentation, a judgment from a chosen court which has been rendered in accordance with an agreement must be recognized and enforced in the courts of other contracting states. Now, this, of course, if the United States does ratify, would be the first treaty which obliges us as a matter of international law to recognize and enforce judgments rendered in foreign courts. It would be obligatory. I mentioned a fourth optional rule, and that is that states may, by declaration, permit their courts to recognize and enforce judgments of courts rendered in other contracting states where jurisdiction is based on a non-exclusive or permissive choice of court provision. And the current thinking is that the United States would accept that undertaking as well, so that the convention would apply more broadly, not just to exclusive choice of court agreements, although the presumption in the treaty is that agreements that specify foreign courts will be considered exclusive, but it would be also to non-exclusive choice agreements. So you can see that in international transactions, this could have a very powerful effect. And I hope you can see that since it would apply throughout the United States if ratified, it could have a direct effect in state courts where they are chosen or not chosen by parties to a dispute. The convention applies only to international cases, which is a defined term, and only those that involve civil or commercial matters. And obviously where parties have chosen a single court or the courts of a single country. That is, I designate the Superior Court of X or the courts of X. Both would be covered for the resolution of disputes. Importantly, the substantive validity of the agreement itself is not determined by the convention. That remains a question for the law of the state concerned. It's the obligation to enforce that agreement and to enforce the resulting award, which is covered. Just a word of background. As Linda mentioned, this is the result of a longer and more difficult, ultimately unsuccessful effort by the United States to achieve a multilateral convention regarding jurisdiction and enforcement of judgments globally. This so-called double convention, that is one that concerns jurisdiction as well as recognition, did not achieve consensus. We had tried in the Hague Conference for a long period of time to get agreement, particularly with the European countries, that would enhance the enforcement of U.S. judgments. As Linda has said, our judgments tend to travel more poorly, to be less freely recognized than foreign judgments are in U.S. courts. This is a result of a long history, but generally speaking, the playing field for, particularly in the commercial context, is not level. That foreign judgments are more readily accepted in the United States than comparable judgments rendered by your courts or by federal courts are in foreign countries. There are a number of reasons for that, but the effort had been for many years to try to get an agreement on what would be the permissible bases of jurisdiction and the permissible bases for enforcing judgments. Ultimately, that effort in the Hague Conference failed of adoption. There are stark differences, as I'm sure you all know, between our notions of jurisdiction, you've heard some of them today, and those particularly in Europe, which takes as a narrower and more civil law approach to jurisdictional issues. There are objections, for example, to tag jurisdiction or doing business jurisdiction, which really aren't readily accepted in many parts of the world. In addition, there's great concern about the size and nature of many of our awards in tort as well as in contract, for example, in treble damages or punitive damages, and increasingly about the effect of the internet and new forms of electronic commerce. For these and other reasons, it was not possible to achieve agreement on this broader convention, although I think there will be an effort to resuscitate that in the future. What emerged from that situation was agreement on a much narrower convention, and that's the Choice of Court Agreements Convention, looking only at those situations where the parties to the contract have said, we would like to, by consent, we would like to have our disputes settled in the courts of X, and we want to make sure that that agreement is going to be enforced and that the judgment resulting from it will also be enforced. So the new convention is a much narrower focus and in some ways is analogous to the New York Convention on the Recognition and Enforcement of Arbitral Awards. What's the larger perspective on this convention? Well, potentially it's quite significant in the field of international commerce. It could be quite positive in the sense of giving parties a degree of certainty, certainly enhancing party autonomy, reducing the potential for competing litigation and for efforts to overturn awards. And in the increasingly transnational context of commerce, that seems to be a real benefit in the respect of international civil and commercial judgments. As I mentioned, it would likely enhance the enforceability of U.S. judgments overseas in this particular area. For many people, it would promote litigation as an alternative to arbitration in international disputes. Arbitration is increasingly seen as lengthy and difficult and time-consuming, particularly for the smaller or medium-sized claims. It's not worthwhile. Let's just agree on where we're going to litigate and have done. It's going to be cheaper and quicker in many cases. On the other hand, it would require some important changes to U.S. law. Some of these have been mentioned already. Most particularly is the doctrine of forum nonconveniens. The result of this convention, of course, would be to eliminate the doctrine of forum nonconveniens in those cases where the parties have agreed by contract to submit their cases to a specified court. Some litigators would say, and I've heard some judges say, what, you're going to take that option away from me? No, the parties have done that. They've said we're going to submit to X court, and that's where we want to have it done. It would also, as I mentioned, change the presumption of, in U.S. law of non-exclusivity, where the criteria of the convention have been met. The other question, which is of some importance to you, I think, and bears some discussion, is the issue of implementation in U.S. law, because it would pose some significant challenges. There is, of course, significant federal law in the area of enforcement of judgments and in the area of choice of court agreements. You're familiar with Hilton versus Guyot and the Bremen versus Zapata. But as Linda said, in both areas, these are by and large questions of state law. And if they exist if their cases are brought in federal court, they're brought under diversity jurisdiction for the most part. And the result of ratification of this treaty would necessarily be to impose a federal standard. So in a sense, this convention poses a very stark question under the Supremacy Clause, Article 6 of the Constitution, as to the relationship between federal and state law. Now, the overriding criterion for the U.S. government, particularly the State Department where I used to work, is compliance with the treaty. Our concern is always that when we ratify a treaty, we want to ensure that we would be compliant. So in this case, we want to be sure if we ratify this treaty, which is generally considered to be a good thing for U.S. commercial parties and for litigants, we want to be sure that the provisions of the treaty are given effect. How do you do that? Well, there are several options. One is to declare the treaty to be self-executing. And for those of you who are knowledgeable in the lore of treaty law, what that means is it becomes effective as federal law on its own terms. No need for implementing legislation. It simply now displaces all inconsistent state and pre-existing federal law, so that it would magically become the law throughout the country, directly applicable. Or secondly, it could be implemented by federal legislation, which has its own difficulties, but in the case of the New York Convention on the Recognition and Enforcement of Arbitration Awards, that's how the issue was handled. A third option exists and is under consideration, and that's some sort of joint implementation method in conjunction with or resting on uniform state law. Because this area is largely a question of state law, and even if the treaty were ratified, there would still be significant areas that would be governed by state law. For example, the validity of the contractual provision, potentially questions of public policy. Consideration is being given to implementation on a two-step process. That is, there would be federal legislation, but there would also be a uniform state law, not unlike the Uniform Money Judgments Act, which would give effect to the treaty within the states that adopt this law. That might be all the states. If it were less than the states, all of the states, then the ones that hadn't adopted the uniform law would be subject to the federal law. This has been given the rather nice name of Cooperative Federalism. Other people would call it other things as well. This is a matter of some controversy. Many people say, oh, this is too complicated. What we need is a single standard for litigants, particularly foreign litigants, and let's not have duplicative issues. It just becomes too complicated. On the other hand, there are strong voices that say, look, this is an area of state regulation. There will still be lots of state issues, and just because the government has itself a treaty doesn't mean it can waltz in and take over this area of the law. If I were a state judge, I might say, look, you're dealing with my jurisdiction. and that's a matter for the state legislature and so on. So there are complicated issues on the implementation side. The Uniform Law Commission here in Chicago is working on a uniform implementing legislation. The federal legislation is being drafted. How these two things will fit together is still something of a mystery and a fascinating legal issue. It is an issue for you all to watch and to think about. And I mention all of this with great trepidation because Linda in particular has had a strong voice. She has, of course, been involved in the implementation and of judgments and a proponent of a federal legislation that was generated primarily for the pre-existing and unsuccessful convention. So there are strong voices, but I thought it would be worthwhile taking a few minutes to introduce you to this treaty. It is coming to a court, yours or another one, near you at some point soon. On what basis yet, we don't quite know, but it's going to be debated probably next year in the Senate. Thank you.